I'd like to go ahead and get started if there's no objection. I'd like to welcome everyone. This is the meeting of the Senate Medical Affairs Committee. I pray that God continues to bless us all. Welcome everyone. You have the agenda before you. First of all, we have statewide appointments. I'd like to call up Ms. Seema Srivastava Patel from Lexington, Board of Health and Environmental Control. Good morning, ma'am. I'm sorry? Well, I've been worried about it all night.
Oh, making the chairman worried. That's very cool.
Thank you. Well, for the record, if you would give us your full name.
It's Seema Srivastava legally, but I go by Seema Srivastava Patel.
Okay, great.
My husband's back there.
Okay, good. Welcome. Let me swear you in. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Would you like to make a brief statement to the committee while you'd like to serve on this board?
I would. Mr. Chairman and members of the committee, I'd like to say that it would be an honor to serve the state of South Carolina in the Board of Health and Environmental Control. I was born and raised in South Carolina. I'm a graduate of USC. I'm president of Caroline Convenience Corporation. We own convenience stores that supply fuel. We own a chain of restaurants, and we're located in Lexington, South Carolina. We employ over 200 employees. I would say that with my business background, I'll be able to bring value to the board of DHEC. On a personal note, like I said, I was born and raised in South Carolina. I grew up with the most beautiful beaches, the most beautiful rivers, the most beautiful lakes, the most beautiful mountains, and the most beautiful land. And now that I have children and I'm raising them in South Carolina, I want them to inherit the same South Carolina that I grew up with. I want future generations to be able to inherit the same South Carolina that I grew up with. So again, I'd like to say what an honor it is to be appointed to the board of DHEC by the governor, and I'd like to say thank you for your time.
Thank you for your willingness to serve. Staff has a few questions for you.
Thank you. Ms. Srivastava is from Lexington. She is being appointed to the 2nd Congressional District seat with a term which commenced on June 30th, 2017, expiring on June 30th, 2021. Her paperwork is all in order, and we've received everything that we need from her. But if you will answer these questions.
Yes.
Do you or any member of your family own or operate any business which contracts with state or federal government?
No.
Do you or any member of your family own or operate any business which receives state or federal funds from DHEC?
No.
Have you ever been arrested, charged, or held by federal, state, or other law enforcement authorities for violation of the law, regulation, or ordinance?
No.
Has a tax lien or collection procedure ever been instituted against you personally by federal, state, or local authorities?
No.
Have you ever been disciplined or cited for a breach of ethics or unprofessional conduct by any court, agency, association, or professional group?
No.
Are you now or have you ever been employed as a lobbyist or acted in the capacity of a lobbyist principal?
No.
Do you know any reason you would have difficulties performing the duties of the DHEC board?
I do not.
Thank you.
Thank you. Senator from Spartanburg, Senator Martin, had to be out of town and he can't be here, but he wanted me to read this into the record. He said, I am well acquainted with Seema and very familiar with her work, ethic, and character. Therefore, I'm confident in recommending Ms. Patel for the DHEC board. She is brilliant and accomplished executive, and who I have no doubt will be an asset to South Carolina and DHEC. He wanted me to read that into the record.
Thank you.
Thank you. Any members have any questions or comments? Senator from Lexington, Ms. Shealy.
I also have a comment that I also know her personally and think that she would be a great asset to the board, and she does a great job at what she does personally, her business, and she's a great asset to our community in Lexington, and at the appropriate time, I would like to move for a favorable report, or however we say that here.
Okay.
Thank you.
All right. We will. Senator from Charleston, Senator Kempson.
Good morning.
Good morning.
How are you?
I'm great. How about you?
Good, good. Are you aware that DHEC supervises rules and regulations with respect to the permitting of chicken farms.
Oh, they're into everything.
Yeah. So that's one of the industries that comes under the purview of DHEC. We recently discussed House Bill 3929. In fairness to you, you were not a board member. But that discussion consumed several days of debate on the Senate floor. Do you think it's, and this is, it's okay if you don't want to answer this question. Do you know whether board members get involved in setting the policy in South Carolina for DHEC's rules and regulations?
So I want to make sure I understand your question correctly. The question is if DHEC board members get
Have
involved with the
input.
policies.
That's right.
In implementing them or developing them?
Developing them, consultation with the executive director.
You know, Senator, I don't know the answer to that question, but I can get back to you in a timely manner if that's all right.
It's okay. What was a major portion of my concern? And I just want you, as you go forward, because you got a lot of support, and I'm impressed by your business background.
Thank you.
In sum, this agency has given away their authority to regulate the setbacks with respect to chicken growers. You know, chicken growers can have as many as 100,000 chicken in a neighborhood where people live. I guess my time is up.
Or it's this comedy hour because I'm up here.
Take that as a sign, Senator Austin.
Chicken farms.
Yeah.
They can have, DHEC has the ability to regulate the setbacks required. And this agency has voluntarily agreed to relinquish their authority with respect to setting those setbacks because of this bill. It was my position that we ought to have DHEC involved on a case-by-case basis because there is not one setback that can be applied to every situation. For example, in the bill that we passed, chicken farms would be allowed to set up within a certain number of feet, I think it's 400, from a river. You talked about you like the rivers and lakes, and I understand that. If the rivers and lakes are contaminated with chicken waste, then we won't be able to enjoy them as well. So as you go forward, I would encourage you to monitor the executives, the administrative personnel in charge to make sure that this example doesn't become an example for other big industry who petitions this state house to roll back regulations which limit the rights of citizens to petition big chicken houses from moving in residential communities and where they might be somewhat detrimental to the private enjoyment or the enjoyment, public enjoyment of our natural landscape in South Carolina.
I'll remember to keep that in mind.
Thank you.
Thank you.
Thank you, Senator. Senator from Anderson, Senator Gambrell.
Thank you, Mr. Chairman. I'd just like to reiterate what the senator from Spartanburg said in his remarks and the senator from Lexington. Seema and her family and my family usually end up at the same conference together every summer, and I'm on the legislative panel. Most time the legislative panels are pretty easy list, but I'm gonna tell you, she keeps us on our toes with a lot of hard questions, and if she carries that attitude to DHEC will be better for her being a member of this board.
Thank you for saying that.
Senator from Orangeburg, Senator Hutto.
Good morning.
Morning.
We have had the unfortunate occurrence in most small counties to be faced with crises with our hospitals, and in fact, several have closed. And now we are faced with the bigger hospital systems merging. And I know if you're from Lexington, you've got a fine hospital over there in the Lexington Medical Center. But do you have any opinion or anything that you could share with us about what you see? I mean, one of the main things that DHEC does is oversee the health part of that, and a lot of that goes to hospitals and certificate of need, which has been, the chairman will tell you, the subject of many discussions over many years of whether we need certificate of need or we don't. But do you have any background in hospitals or any thoughts that you would share with us about what you think about the future of the hospital system in South Carolina?
You know, I have my opinions, but recommendations, not as yet. I would say that I would need to sit back and really look at and read the information and come back to you. I really don't have an opinion on that just yet. But if you would like me to, I could.
No, I just want you to put that on your radar screen, because there are many who think that probably within 5 to 10 years there may be only 3 or 5 hospitals in South Carolina.
Right.
You know, if Greenville and Columbia merge and the rural hospitals are closing or being taken over by the larger regional hospitals, it won't be long before we just got 3 hospital systems, 4 or 5, whatever, in this state. And that's a big change from what people are used to, which is going to your local hospital. And so it's going to be a big change, and I think it's going to be something that lands directly in front of the DHEC board potentially. So I just want to make you aware that that's something I think you need to study up on.
I have a lot of friends that are physicians, I'm aware. Yeah.
Okay. Well, now the physicians have a totally different opinion about
Yeah,
what
they
ought to
do.
happen to the hospital.
And you have to take both sides, I'm
That's
aware.
right.
Yes, sir. Thank you.
Senator from Lexington, I think the time is appropriate. Senator from Lexington, Senator Shealy moves favorable, seconded by Senator Davis. Any other discussion? Hearing none, we'll take it to a vote. All in favor, raise your right hand. Thank you. It's unanimous.
Thank you.
Thank you again. Next, we have Mr. Rick Toomey from Beaufort. DHEC Board. Good morning, sir.
Good morning.
Yours was a little easier to pronounce. But for the record, if you would give us your full name.
Richard Kirk Toomey.
Good. Let me swear you in. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Would you like to make a brief statement?
Please, thank you. Chairman Peeler, distinguished members of the Medical Affairs Committee, I am honored to be here today to be considered for appointment to the South Carolina Board of Health and Environmental Control. If confirmed, I look forward to working with other board members and the agency's leadership in representing the citizens of South Carolina. Again, I'm honored to be considered and honored to continue my family's involvement within the state of South Carolina, and I'm ready to answer questions.
Good. Your family, you are Bob Toomey's
Brother and Bob Toomey's son, depending upon
okay.
which Bob you're talking about.
I understand that. Okay. Staff has a few questions for you.
Thank you. Mr. Toomey is from Beaufort. His is an initial appointment to the, representing the 1st Congressional District with a term that commenced, is an unexpired term, commenced June 30th, 2015, and will expire June 30th, 2019. He is the retired CEO of the Beaufort Memorial Hospital. He lives in Senator Campson's district. Senator Davis, I checked this morning. His paperwork is all in order, and if you will answer these questions. Do you or any member of your family own or operate any business which contracts with state or federal government?
No.
Do you or any member of your family own or operate any business which receives state or federal funds from DHEC?
No.
Have you ever been arrested, charged, or held by federal, state, or other law enforcement authorities for violation of the law, regulation, or ordinance?
No.
Have you, to your knowledge, ever been under federal, state, or local investigation for possible violation of a criminal statute?
No.
Has a tax lien or collection procedure ever been instituted against you personally by federal, state, or local authorities?
No.
Have you ever been disciplined or cited for a breach of ethics or unprofessional conduct by any court, agency, association, or professional group?
I have not.
Are you now or have you ever been employed as a lobbyist or acted in the capacity of a lobbyist principal?
No.
Do you know any reason you would have difficulty performing the duties of the DHEC board?
I do not know of any reason that I could not perform the duties.
Thank you.
Thank you. Questions or comments from members? Mr. Lawrenceburg, Mr. Tata.
I'm gonna get to the hospital question with you in a minute, but let me ask this other question first. As I understand it, there are several vacancies on the DHEC board, and of course, if we confirm the two of you, there's still gonna be several vacancies on the DHEC board, and they're in the midst of a search for a new commissioner of DHEC. And I don't think there are but two members right now on the search committee. Do you have an opinion about whether y'all ought to have a full complement on the board before you actually hire the commissioner that'll be there and oversee DHEC for its future years? Or do you think that the few of you that'll be on the board now without the full complement of members should go ahead and fill that vacancy? So the question is, you think you ought to wait, or do you think you ought to go ahead?
I would trust that the current board, although, as you acknowledge, minus two members and replacing those two, have been doing a process, a search process, and I understand that they have scheduled a meeting that would, if we are confirmed, would at least include us in that. And so I would say it's preemptive for me to make an opinion until I get through part of the process to see where they are, what are the candidates that they have. As the CEO of a hospital, I've undertaken many executive searches, so I feel comfortable in being brought into the process, but do not have an opinion whether they should stop and wait until the full complement of board members should be there or not. But I think with their decision to reschedule the March meeting into a date at which we two could be there is a good step.
Let me go back. You were here when I asked the question about the hospitals, and I'm from an area where we've lost several county hospitals, and then I also know that many of my other rural county hospitals that may still be open are struggling, and several have already been taken over. And I say taken over in a polite way. I mean, probably for the positive, but taken over by a larger, what used to be a regional competitor, so to speak, but somebody else in the region. And now we've got the news that Greenville and Columbia are looking at merging, which would create a huge hospital system in South Carolina and almost suggestively force other regional hospitals to want to get into some sort of alliance to be able to compete on an even footing with something as big as the Greenville-Columbia system. And then we've got the whole idea of the teaching hospitals, and could the medical university fit into a model where they could get into a group setting. You have a hospital background, and you're aware that DHEC plays an essential role in the CON process. Do you have any opinions about the viability of the CON process and what role DHEC should play as we look forward to determine the future of hospitals in South Carolina?
There's a litany of questions incorporated into those comments, and let me try to take a couple of those, and if I miss one, I'll be glad to circle back. Yes, I have a background in healthcare. I have been a hospital administrator for 37 years, 38 years in varying degrees, healthcare consulting for a period of time. But I have watched, and my profession and my career has been with the smaller, regional, mid-size community hospitals, and I believe that there is a critical role that community hospitals play within their community in meeting the needs. We also, over the 30 years, have seen the change of systems growth and how the economies of scale and how the challenges of both nurse recruitment and physician recruitment strain the capabilities and the capacity of smaller hospitals to either recruit and or retain critical manpower. So alliances have helped over the years. Beaufort Memorial 5 years ago went into an alliance with the Medical University of South Carolina. It's a non-governmental alliance, but how can we work together looking at efficiencies and knowledge and expertise that they can provide us? And I think Orangeburg has a similar relationship with MUSC. So I think the status quo has gone by the wayside. I think hospitals have to look at a new day as to how to continue to meet the needs of their community. That may be at times looking at a larger system to either be acquired or to develop a relationship with. I would say that the DHEC board and certificate of need process has had a lot of pluses and minuses over the years, but a lot of that relates to federal and state law. And I think at the end of the day, the federal and state law will determine or will set boundaries as to whether or not some of these mega mergers can or will be allowed. Just as a side note, my father, Bob Robert Toomey, was the first, was administrator of Greenville General in 1952 and developed the Greenville hospital system and retired in 1979. So I'm certainly familiar with Greenville, my hometown, and what they're doing, and certainly have a lot of friends at Palmetto. And I think that they are looking at how can we be competitive in the marketplace and bring economies of scale, but that also at the same time runs risk of creating a very large entity. So I think the jury is out on those. The federal government, the state government is out on the decision as to whether or not some of these mergers will occur. But local hospitals have to survive in some form or fashion to provide care at the local level.
Let me ask you one follow-up. What about out-of-state hospitals acquiring South Carolina hospitals?
There's two, as you would say, out-of-state hospitals. There are like the Carolinas Hospital, Carolinas Healthcare out of Charlotte certainly has been involved and has relationships with other hospitals. And then you have the for-profit or the proprietary hospitals, HCA, Humana, Community Health Systems that are nationwide. And I think that will continue to have an opportunity for those larger national systems to come in and work with local communities. And if the local community, be it the representative board or the county commissioners, believe that that is the best action to take, they'll work in that form and fashion.
Okay, thank you.
Any other questions or comments? Senator from Charleston, Senator Kempson.
Mr. Toomey, good
Yes,
morning.
Good morning.
You were here when we had a brief discussion. Are you familiar with the chicken bill?
No. To be honest, although, enough of it, and I spent 19 years in North Carolina, so I'm familiar with some of the discussions, although instead of being chickens, it was hog farming.
Sure.
So I understand some of the dynamics.
Good. And so this bill that we passed a few days ago, the House passed it first. Of course, we passed it, but we made some amendments to it that I think are friendlier to people that live in the vicinity of a chicken farm. But in this bill, it essentially takes DHEC out of its discretionary power to increase setbacks from property lines. In fairness to you, you weren't part of DHEC when the bill was making its way in the State House, but as a medical professional, do you have any reaction to that?
Medical and chicken, other than for flu shots, I'm not sure I would make that leap of having that expertise to give an answer right now.
Sure. And so there are a lot of illnesses associated with
Yes.
the waste products from chicken. We got a list of them. There are a lot of ecological concerns as well. I only raise this point because DHEC regulates a number of different industries. And although this bill was better when it left the Senate, we had to spend some time on it, and we worked in a bipartisan fashion to craft a resolution that protects citizens' ability to appeal permits granted by DHEC. And in the future, as a board member, I just want you to be cognizant that if another bill comes over here where DHEC agrees to voluntarily relinquish their ability, you know, I want you to be vigilant and make sure you ask the proper questions and understand the purported reasons that DHEC would have such a position.
I think as I reflect, their vision statement is healthy people living in healthy communities. And what you're saying is follow that adage, making sure that healthy people are living in healthy communities.
Correct, correct. Thank you.
Mr. Toomey, you could look back at the archives of ETV on the Senate for the last couple of weeks, and you will learn everything you need to know about chicken farms from the Senator from Charleston.
I will do so.
Probably more than you need to know. What's the desire of the committee? Senator from Beaufort? Senator from Beaufort, move favorable report. Seconded. With the discussion, we'll take it to a vote. All in favor, raise your right hand. Thank you. Unanimous. Thank you, sir.
Thank you.
That's two great appointments there for the DHEC board, I think, both of you. Next, we'll go to general bills, tab C, H 3548. Members, the chairman of the subcommittee was Senator Martin, and as I said earlier, he couldn't be here, but Senator Davis, a member of the subcommittee, said he would carry the subcommittee's report for today. Senator Davis, you want staff to, or would you like for you to present it?
Sure, I'll go ahead and take a shot at it and ask Martha if she'll go ahead and just supplement anything that I miss.
Davis.
This is a bill that would add a new article to the abortion chapter in Title 44 to ban what has been characterized in the bill as dismemberment abortions. And dismemberment abortion is defined on page 2, beginning on line 11 of the bill, as follows: the intention of causing the death of an unborn child, knowingly to dismember a living unborn child and extract him or her one piece at a time from the uterus through the use of clamps, grasping forceps, tongs, scissors, or similar instruments that through two rigid levers will slice, crush, and or grasp a portion of the unborn and cut or rip it off. We had physicians, Mr. Chairman, that testified at the subcommittee, and that procedure is known in the medical community as a dilation and evacuation. There is an exception to the bill's ban on dismemberment abortions pertaining to instances where there is a serious health risk to the unborn child's mother, beginning on line page 42, it defines that serious risk as follows: in the reasonable medical judgment, the mother has a condition that so complicates her medical condition that it necessitates the abortion of her pregnancy to avert her death or irreversible physical impairment of major bodily functions, psychological or emotional issues not included. And just by way of reference, Mr. Chairman, that's the same definition of serious risk, health risk to the unborn child's mother that was included in the bill that we passed a couple of years ago, the pain-capable 20-week bill. It also creates legal actions that certain individuals with standing would have an action against a physician who performs a dismemberment abortion, guilty of a felony, $10,000 and or 2 years imprisonment. Those with standing include a father, if married to the mother. If the mother is under 18, standing is also given to parents who can bring a cause of action against the physician for actual and punitive damages, costs, and attorney's fees. There's also a provision in the bill for injunctive relief that may be brought against a person performing a dismemberment abortion as defined in the bill. The bill also makes it clear that this bill does not ban any other form of abortion or abortion by any other method. It does not include suction. It is limited to the banning of the use of clamps, grasping forceps, tongs, and scissors. There are 8 other states in the country, Mr. Chairman, that as of September 2017 have adopted similar legislation: Alabama, Arkansas, Kansas, Louisiana, Mississippi, Oklahoma, Texas, and West Virginia. After receiving testimony, the bill passed at a subcommittee favorable report, I believe, on a 3-2 vote.
Thank you.
I would ask Martha to supplement or add anything that I may have missed.
The one thing we did receive yesterday afternoon is the fiscal impact. The House, when it came from us, they did not get a fiscal impact. It's required by law. They didn't get one, but we have gotten a fiscal impact on it, and there is none to the general fund.
Questions? Senator from Clarendon, Senator Johnson.
Thank you, Mr. Chairman. I noticed that Senator from Beaufort, Senator Davis mentioned other states with similar legislation. Can you tell me, or can anybody tell me what the status of those legislation, or that legislation is in these other states? Are they actually have the ban gone into place, or is there litigation, or whatever the case may be for those states where you said they have adopted similar legislation?
Yeah, Senator Johnson, it's my understanding, and there was testimony given at the subcommittee hearing that, and I'm not sure in which states the legal challenges have occurred, but it's my understanding that there have been actions challenging the legislation that are currently pending either in federal district court or in the Federal Court of Appeals in the event the district court has reached a decision. There has been no adjudication, to my knowledge, of the constitutionality of this particular legislation by the United States Supreme Court. But I do believe that there are challenges that are in various stages within the federal court.
I asked that question because I think that although this legislation was adopted, I think the bans are still in place due to pending litigation, which I understand is very, very costly to these states. And I often wonder sometimes that those who propose this bill, since this is it's probably the exact bill, or at least almost the exact bill that has been entertained in these eight other states, why do we want to waste so much time and so much money when we don't have any money? And I wonder sometimes why we just don't wait until these cases or this legislation is litigated in other states, because I think we know the answer. And I'm just wondering why we, unless we had some kind of magic potion that it would work in South Carolina, it would pass litigation here. But I'm just concerned because of the fact that it has passed in these other states and it's being litigated. And so far, the courts have not, as far as my knowledge, made any type of determination to allow the bans to go forward.
I think Senator Johnson, if I could respond, I think one of the reasons is that you have different circuits throughout the federal system. In one of the instances that will cause the United States Supreme Court to accept certiorari or jurisdiction over a case is if two different Federal Court of Appeals have reached different conclusions in regard to the constitutionality of the particular law. And so I think the idea is that even though there are actions being litigated elsewhere in the federal system, again, one of the grounds for the United States Supreme Court accepting certiorari and hearing a matter is if there are two differing decisions issued by courts of appeals in the federal system. So I think that's one of the reasons why there is a utility to having the particular matter litigated in our circuit.
Hutto?
I'd like to follow up on what Senator Johnson was just saying. In fact, in Alabama, it's been declared unconstitutional, and in Texas, it's been declared unconstitutional, and currently it is blocked in Kansas, Oklahoma, Louisiana, and Arkansas due to pending litigation, and those litigation costs are running millions of dollars. And so if you want to end up paying $2 million to Planned Parenthood, then pass this bill, because what's going to happen is they're going to challenge it, and you're going to be ordered to state, and I know they're saying there's no fiscal impact, but there's going to be a huge fiscal impact to this state, because I think we all know it's going to be challenged, and we know that the state's going to have to pick up the bill. And not only are we going to have to pick up the bill for our Attorney General or whoever he hires to represent the state, if we lose, we're gonna have to pay, and I know the chairman's a big proponent of loser pay. We're gonna lose and we're gonna pay, and the average cost has been about $2 million. And so, this is one way that if we wanna make sure that we got less money in our budget or in our insurance reserve fund, is to pass this bill. Having said that, I realize that this bill is gonna get a favorable report this morning, and so I'm not gonna, try and hold it up unduly, but I would suggest to you there are a few things that we have always done as bills of this type have come through this committee, and one is to try not to so criminalize the practice of medicine that we deter hospitals from being able to recruit quality physicians to come to South Carolina with the fact that there's a potential felony hanging over their head. And we did this in the other legislation, the 20-week and all, and we changed it to a misdemeanor, and I hope that maybe if this does get debated, I hope it doesn't, but if it does get debated on the floor, we'll look at that. And we also have taken out all the litigious parts of other similar bills where we've tried to encourage people to sue other people. And furthermore, the bill flips back and forth between the use of physician and person who performs, and those not necessarily the same, because there'll be nurses and hospital staff and other people. But what I really want members of the committee to know is that this will not affect 99% of the abortions in South Carolina. It's a limited, very limited few that happen in the late trimester, and the reason is most often that the mother's life is in danger. And what is being done is an attempt to save the mother's life. And so, to me, y'all, I say y'all, whoever, if what you're trying to do is change policy, you're aiming at the wrong target, because these are situations in which we're asking doctors at a time when the woman's life is probably most critical. She's, 7 or 8 months pregnant, and something terrible is, look, if a woman is 7 or 8 months pregnant, she is pretty much committed to wanting to have that baby, all right? This is not a situation where all of a sudden that she's just saying on her own, I don't want to do this. This is a situation in which the doctor says, if you don't do this, your life is in danger, and your other 3 children that you've got at home may end up without a mother. And what we're doing is we're saying to the women of South Carolina, if you've got enough money and you can fly up to D.C. or New York or Virginia, wherever you can get this done. But if you're poor and you have children at home, you're just going to have to run the risk of losing your own life for your own health in a circumstance like this. And the suggestion that the unborn child could be given some sort of anesthesia, whatever, it's like threading a needle. You would have to penetrate the woman's abdomen with a needle, a long needle, and you'd have to hit it in the target size of a peanut. And if you miss, you're going to kill the mother. So it is really a very risky procedure that you're setting up for a doctor to do even under these circumstances. So I understand I'm not going to change any minds here this morning, but I just want to tell you that we're destining ourselves to a huge lawsuit, and we're destining the women who don't have means in South Carolina to a very risky outcome in the unfortunate event that they find themselves one of those women who the doctor calls up and says, I just read your last report, and you've got to come in and have this procedure, otherwise you may die.
Senator from Richland, Senator Scott.
With the senator from Beaufort Youth for question.
Senator Yields.
Senator, legal action number 2, if married to a mother, father can bring action. Suppose this couple has not been together for a number of years, and suppose both of them have separate lives, they've been living but never got a divorce. And so and suppose the child that's being discussed, or the unborn that's being discussed, is not even his child. I noticed in the language of the law did not extend to any of those situations that's in the law. And I noticed it had not been expanded to make sure these folk are living together. Because it may be a case where that father may look at it as an opportunity just to bring a lawsuit for the purpose of gain. That brings me a lot of concern. So I was just kind of surprised that that portion of the statute, if you adding this to the bill, did not cover all those particular actions. And while you're also thinking about that, I also noticed that the charges were $10,000 on a felony, 2 years in prison. Is that in line with the normal sentencing guidelines for what? Is that murder, premeditated? I mean, just what, or is that just a figure that we just kind of pull out of the air to create in the statute, when the other portion of the 20-week bill talked about and gave the judge some flexibility from 2,000 to 10,000 or 3 years in prison. But I noticed there's very little flexibility on the fine side, as well as whether or not it's a misdemeanor or a felony. So I'm trying to figure out when whoever wrote this thing and looking at it, is it in line what normal charges are in South Carolina, since we spent a lot of time trying to bring all the stuff in line, and how far out are we? And then you've got the mother under the age of 18, and if this mother under the age of 18, he may have already gotten consent from the parent to be married. I'm trying to figure out how the parents come back into an action on a child who is legally an adult at that point. And so it was just a lot of conflicting questions that really that really conflicted with state law that gave me a lot of concerns. Thank you. Thank you, Senator.
Thank you. Any other? Mr. Davis?
I would just simply, the Senator Scott sent from Richland, you're correct in, on page 2 of the bill in section C1, it is very specific in regard to who has standing in regard, as you pointed out, and further in regard to the criminal penalties. You're correct in reciting. It's my understanding that the author of the bill in the House looked at legislation that was adopted in the 8 other states, and I think that language in regard to standing and in regard to penalties is reflective of what's in those other states. I can't make a comment as to what it would correspond to in South Carolina for another offense.
Mr. Chairman, thank you, Senator from Beaufort. And that really runs foul with our statutory laws and what South Carolina says these particular type cases for penalty should actually be. That creates a major problem, especially when we try to codify it as well as look at what we already have on the books, and creates a total confusion with judges trying to sentence people based upon what their actions have actually been. Thank you, Senator.
Senator Shealy.
Yeah, I'm not an attorney, and when we hear all this legalese, but I'm going to get down to the crux of this thing. You know, we sit here and we talk about the fines and we talk about all the penalties and the numbers, but let's talk about this first paragraph. You know, I heard the senator from Orangeburg talk about, well, the baby's probably, the mother's probably in the 8th month and all this. Well, the intention of causing death to an unborn child, knowingly to dismember a living unborn child and extract him or her one piece at a time from the uterus through the use of clamps, grasping forceps, tongs, scissors, or similar instruments that through 2 rigid levers will slice, crush, and or grasp a portion of the unborn and cut or rip it off. Now, come on. Do we really want that to happen? I don't care. This child has feelings. This child can feel. Do we not think it's humane to give the child anesthesia before we do that? I mean, if this was a bill about puppies or chickens or whatever, we would have people lined so far down that hall to save a dog that we couldn't get them in the building. but we're talking about feeling sorry for unborn children, and we're fighting over whether or not we want to euthanize them before we tear them apart. I just can't even understand why we're having an argument here. And no, I'm not an attorney, and I'm not going to argue about whether we charge people $10,000 or whether we give them 2 years. I'm talking about children, and I'm talking about feelings, and I'm talking about these children can feel this. When you're talking about an 8-month-old fetus, an unborn child, and you can talk about Planned Parenthood all you want, and you can shake your head, and you can do that, but we're talking about somebody that has feelings, and that baby can feel. Thank you, Mr. Chairman.
Thank you, Senator.
Chairman.
Senator from Charleston, Senator Kempson.
Thank you, Mr. Chairman, and I'll direct this question to Senator Buford, since he is given the subcommittee report. Senator, do you know how often this type of procedure is performed? What percentages of abortions in the second trimester are performed by dismemberment?
There was testimony by physicians at the subcommittee level that talked about that this dilation and evacuation procedure was not a rare one. In terms of percentages or in terms of, you know, how often that's done relative to others, I don't know. But it was not my impression at the subcommittee level that we're talking about something that only occurs, you know, once in 1,000. I got the impression that it was within the common accepted practice of how abortions are performed in South Carolina.
It's significant enough, in your opinion, it's not a rare occurrence.
It wasn't my impression, Senator from Charleston, at the subcommittee that it was a de minimis or a 1 in 100 or 1 in 1,000 kind of a thing. It was. My impression upon listening to the physicians at the subcommittee hearing was that it wasn't extraordinarily rare, but I can't give you a percent. I don't have a percentage.
And that the reason why I asked that question is because certainly I'm trying to gather my information for the floor debate, and so we'll circle back if this bill makes it out of the committee to talk about the percentages on the floor. Second question is the procedure that the senator from Lexington described. Do you know whether or not that procedure is prescribed on a viable fetus or a non-viable fetus?
Yeah, I can only speak as to what the prescription in the bill is, and it states that the procedure is not permitted in regard to a living unborn child, and that's the prescription. And there has to be a living.
So the doctors have permission to do it on a living viable fetus?
No, the ban, the dismemberment abortion ban would apply
to living
unborn fetuses.
And do you know now what is the practice?
In terms of the dilution and evacuation?
Yeah.
Is that the dismemberment does occur in regard to a living unborn fetus. And there was actually testimony and visual testimony with a plastic baby was brought out and forceps, and one of the physicians actually went through the process of describing and showing us how limbs and members would be taken away from that, and that was compelling visual evidence given to the subcommittee members.
You know anything about the chain of custody of that video? Was that video shot in South Carolina?
It wasn't a video. It was like a baby
Demonstration?
Demonstration, yes, right.
You don't have any video of that?
I do not personally know.
I'm curious, the author of this bill is from Charleston. I don't believe she's a medical doctor, Representative Lynn Bennett. What did the medical community? What was the testimony in the medical community about this procedure?
At the subcommittee level?
Yeah.
I would, as I recall, and I'll defer to staff, but I think it was fairly evenly divided. We had we had physicians that would testify as to this is within the norm of what is done in performing abortion services, and then we had other physicians who provided testimony as to this particular dilation and evacuation procedure not being humane, not being something that our society should tolerate. So my impression was you had physicians on both sides of this issue and relatively equal numbers in terms of testifying.
So the medical community was split. There was, in your view, there was not a weighted testimony in favor. There was equal testimony on both sides.
At the subcommittee level, I don't know if you can extrapolate beyond that and say that's reflective of how the community statewide feels, but at least in terms of the testimony we received, there was about an equal number of physicians for and against this bill.
And what if the medical physicians who perform these operations don't use this type of procedure, what are the other procedures available? Are there other procedures?
Yeah, yes, there are. Suction. I mean, and again, I don't want to get out of my area of expertise, but this is not taking off the table the only method available. And in fact, the bill expressly states that it does not prohibit or prevent abortion by any other method, including suction. Suction would still be permitted. So I guess the only way I can answer that question is it doesn't take away the only abortive method that is available to physicians. Okay. It takes away a particular one.
Thank you.
Yes, sir.
Senator Scott, did you have additional questions?
Some water.
No? Okay.
Some water.
Senator Hutto?
Yeah, just briefly. It is, I mean, I don't know what your definition of rare is, but it is uncommon. I mean, less than 2% of these after the second trimester abortions take place. But be that as it may, I don't think that's going to change any much. I just want to respond briefly, though, to the senator from Lexington. And I understand the passion with which she says what she says, but you're also talking about the life of the mother, which is at stake. And to me, it's just, there's no way that we're going to do justice to pitting two lives against each other. And to suggest that the safest way to perform an abortion and protect the life of the mother is being taken off the table. And I know we can argue this around and around, but I just don't think that adds to the conversation. I understand you're passionate about it, but when the doctors come and say that when a mother's life is at stake, and she, in consultation with her husband, her minister, her doctors, and everybody else says that I need to do what I need to do to save my life for my other children, that she ought to have the safest available choice available to her. Thank you.
Motion is a favorable report. Is there a second? Second is heard. No other discussion. We'll take it to a vote. Members, what I'll do is a show of hands. Please keep them up so staff can have a record of your vote. All in favor of the motion, please raise your right hand. Hold them up. Allow staff to. And I have two proxies, one from Senator Martin and one from Senator Campbell. They also want to be recorded in the affirmative. You have this down? Yes. Okay, now lower. All opposed to the motion, raise your right hand. Please keep them up for staff for the record. Senator Hutto has Ms. Bright Matthews proxy. What's the vote? On a vote of 9-6, the motion passes. H 3548 received a favorable report. Thank you. Members, I know emotions are sky high on this issue, and as chairman, I want to appreciate the civil tone and discussion of the day. Thank you. Next, we have S 755, controlled substances.
S755 is a bill by Senator Peeler. It will deal with drop boxes. Twice a year in October and April, the Federal Drug Enforcement Administration hosts a National Take-Back Day. Law enforcement agencies can be a host site by registering with the DEA. This bill adds a new subsection to our Controlled Substances Take-Back. It will require the sheriff in each county to maintain at least one on-site drop-off box year-round. The box will be available for the general public to drop off unneeded prescription drugs during regular business hours. There is no fiscal impact, and they had done a survey of the sheriffs around the state, and most of these already do it, but this would require it to have a drop box during regular business hours.
Senator Davis, Chairman of the Subcommittee, you have anything to add?
No, sir. That's a good summary by Martha. I will say that the subcommittee members, Senator Johnston and Senator Shealy, we met and we unanimously gave this a favorable report to the full committee at the appropriate time. I would move adoption.
Okay. If you would, the Lieutenant Governor's here, and he wanted about 30 seconds.
Okay.
Thank you, Mr. Chairman.
Mr. President.
Members of the committee. 30 seconds.
For what purpose do you sit down?
I just want to inform the committee, Mr. Chairman, that these drug take-back boxes, we've identified $40,000 in the Office on Aging to assist law enforcement with these boxes. They range from anywhere from 4,000 to 1,200, depending on the size. But we have gone to law enforcement agencies, sheriff's offices, and police departments all across the state, and we have 40,000 now identified. There's an additional 100,000 carry forward in funds that could be transferred to provide funding for the drug take-back boxes, should the agencies ask for them.
Thank you.
Office on Aging can help them with that.
Thank you. Any questions of the Lieutenant Governor?
So, it's good to see you this morning, Mr.
Morning, Senator
Lieutenant
from Charleston.
Governor. So you've identified $140,000 to help the counties install these lock boxes?
Yes, sir. 40,000 now, and should there be a need, there would be an additional 100,000 carry forward that we could use for this. And Senator from Charleston, most law enforcement agencies, most sheriff's offices have these already, but there are some that don't. And should they want help, there's a process we can.
I imagine you could have several per county.
You could, Senator from Charleston. Obviously, it's up to the sheriff. It's up to the law enforcement community. Interesting, it depends on the situation. I'll give you one example. The sheriff of Greenwood, his preference that Lander University not have a box, because I guess the security of it. We were with the sheriff of York, and he would like to have one on the campus of Winthrop. So several locations are a possibility.
And just final question, will there be a grant process, or
Yes,
what do I need to have my sheriff do?
You have them call the Office on Aging, and we'll accommodate them.
You would take care of Charleston County?
Be glad to. Thank you, Mr. Chairman.
Thank you. You need questions of the Lieutenant Governor on the bill? Senator Scott?
I'll yield to the senior member.
Senator Hutto?
Thank you, Lieutenant Governor. I assume that part of this is to try to get back at the opioid situation. But somebody might go get their wisdom tooth pulled, they take 2 pills, now they got, 20 more left in the bottle, and you don't want them laying around, and so you want to turn them back in and safely dispose of them, don't want them to get back out on the street. Is that the general purpose of the?
That is the main reason we're doing this, Senator from Orangeburg. Obviously, we'll take back anything. A lot of folks are just cleaning out their cabinet, but the main goal, and I can't speak for the motivation of the bill, but this is a small solution to the opioid problem, is getting these things out of the medicine cabinet.
And I appreciate that. I think that's wonderful. But my next question is this. We're not going to have a situation where somebody drops off illegal drugs in the box and then they go fingerprint the bottle and go arrest the person for. Is there any provision in here that's kind of a hold harmless if you actually had them illegally, but you decided, hey, I need to get rid of this, that you're. Do you know if there's anything that?
I don't know if that is in this legislation or not. I don't know.
Scott?
Thank you, Lieutenant Governor. In the provision, these locations, since it's going to a daily location, I'm concerned about the security and whether or not other folk can get in that box to get things out. And if these sheriffs are gonna be responsible for it, who's gonna empty it on a day-to-day basis? To make sure, check these boxes on a day-to-day basis to make sure there's nothing left in them.
Mr. Chairman, if I may respond, that's an excellent question, Senator from Richland. And that's the concern that the sheriff in Greenwood had and the sheriff in York County had. Sheriff in Greenwood didn't want one on the campus of Lander because there's not an eye on the box around the clock. Most law enforcement are telling us they want these in a location that outside a building that's manned 24 hours a day. They're not worried about the folks breaking into the box as much as a person coming to drop off a bag of oxycodone, bottle of MS Contin or whatever. But their main concern would be an individual that would like to drop something off and then another individual meet them there and maybe intercept the drop-off. That was their main concern, and that's why.
In essence, the box is secured well enough, a person can't get in that box. 'Cause
No,
you're talking
sir.
about- Well, then that's a problem, because overnight, if someone is on drugs, and that's a normal dropout location, that person overnight can get in that box and get drugs out, especially if you put them on college campuses. I mean, needs of drugs, what drugs gonna be? I'm gonna take my chances and try to get it out, unless we find some secured boxes that you just can't get in or you can't take the box. That's a real concern. So just think about that.
Well, Senator from
Food for
Richland,
thought on that.
these boxes, Mr. Chairman, if I can answer, these boxes are secure. You can't get them. And then they're securely fastened with nuts and bolts in concrete. So it'd be extremely difficult
Okay,
to run off with one of these boxes.
thank you, Mr. Chairman.
Thank you, sir.
Thank you so much, Mr. Chairman.
So, Senator Davis,
At the appropriate time, Mr. Chairman, I would move favorable report.
it's appropriate. Second, any other discussion? Hearing none, all in favor of the motion, please raise your right hand. Got it. Unanimous. Thank you. Now, S 345, Nurse Practice Act. Mr. Davis?
Chairman, I guess I'll just make some preliminary remarks and then maybe have staff talk about it a little bit further.
Okay.
But this has been a bill that has been the subject of intensive negotiations by the two stakeholder groups in this matter. And I think that's the way to start, is that this bill attempts to expand the scope of practice or expand under certain circumstances the things that advanced practice registered nurses or APRNs can perform. And I guess the first thing I would say is looking at the definition of that, because this is the class of individuals we're talking about, and in terms of what they're able to do legally in terms of healthcare services. We're talking about an advanced practice registered nurse, which means a registered nurse who, by virtue of additional knowledge and skills gained through an advanced formal educational program nursing in a specialty area that is approved by the board. The categories of the APRN that are discussed in this bill are nurse practitioner, certified nurse midwife, clinical nurse specialist, and certified registered nurse anesthetist. And the advanced practice registered nurse must hold a doctorate, a post-nursing master's certificate, or a minimum of a master's degree that includes advanced education composed of didactic and supervised clinical practice in a specified advanced practice registered nursing area. So we're talking about very highly trained and qualified individuals. So that's the first thing I would point out. The second thing, the groups that have been meeting have defined instances or how these APRNs can render healthcare services. And what they've agreed to, and what's before you, and what I'm going to submit as an amendment, is something that was agreed to by the physician community and by the nursing community. And it allows for the APRNs and physicians to enter into practice agreements, which have to be updated on an annual basis. And those practice agreements provide a scope of things that nurses are permitted to do. And in terms of what the practice agreement has to entail, definitionally, a practice agreement is a written agreement developed by an APRN and a physician who agrees to work with and to support the APRN, which establishes the medical aspects of care, including the prescribing of medications to be provided by the APRN. And this is an important part of that definition right now that says the practice agreement must contain mechanisms that allow for the physician to ensure the quality of clinical care and patient safety that is maintained in accordance with state and federal law. So we're not talking about untethering advanced nurse practitioners from physicians. We're talking about having them continue to work collaboratively through practice agreements, which must provide for the physician to ensure that the quality of clinical care and patient safety is maintained. So there's not a decoupling, as many of you may have thought. There is still that linkage between what a nurse practitioner does and what a physician does. One of the things that this act does is it removes the existing 45-mile restriction. Currently in the law, a nurse practitioner cannot provide healthcare services more than a distance of 45 miles from where a physician might be located. And that's provided a problem in terms of access to care in rural areas because predominantly physicians tend to be in urban areas, and if you draw a 45-mile radius from where that physician is located, you necessarily leave rural areas outside of those nurse practitioners being able to provide care. So in lieu of the 45 miles, what we have said is that the physician must be readily available, and readily available is a defined term, and it means as follows. The physician who enters into a practice agreement with an advanced nurse practitioner must be able to be contacted either in person, by telecommunications, or other electronic means to provide consultation and advice to the APRN performing medical acts. So in other words, it recognizes and takes into account modern technology whereby nurse practitioners are able to commute with physicians in real time, from distant locations, and that the 45-mile restriction doesn't really make sense in today's world. It may have made sense years ago when you had to have the physician able to drive actually out to where the nurse practitioner was. But technology today makes the physician, quote, readily available, unquote, through telecommunications and other electronic means. The other thing the bill does, currently a physician is only able to have 3 nurse practitioners with whom the physician associates. This would expand it to 6 FTEs or 6 nurse practitioners. So it would expand the universe of nurse practitioners that are out there. There was testimony received at the subcommittee level that in some cases physicians are filled up in regard to the 3 that they're allowed, and others have difficulty finding a physician with whom they can associate. And so the bill makes an adjustment in that regard. The bill also allows for nurse practitioners under very limited circumstances to have prescriptive authority. And in that regard, I would direct your attention to, I'm sorry, sir, let me get it real quick here. Here, I'm not finding it right away, but it's in here under certain, I'm gonna get it just a minute, Mr. Chairman. Yes, thank you, Senator Scott. Yes, it allows nurse practitioners, if it's provided for in the practice agreement, again, that's the predicate. There's got to be a practice agreement between the nurse practitioner and the physician, may prescribe Schedule II non-narcotic substances, again, if listed in the practice agreement, provided, however, that the prescription must not exceed a 30-day supply. Further, may prescribe Schedule II narcotic substances, again, if it's listed in the practice agreement, provided that the prescription is written for patients in hospice or palliative care. It must not exceed a 5-day supply. And other prescription may not be written without the agreement of the physician. And then also may prescribe Schedule II narcotic substances for patients in hospice or palliative care, if again it's listed in the practice agreement, provided that each prescription does not exceed a 30-day supply. It also, one of the concerns that I had, and one of the reasons I filed the bill, was to get more healthcare services into rural areas that in many instances are underserved. And so there is a definition of underserved population, definition number 61, meaning a population residing in rural or urban areas that include but is not limited to persons receiving Medicaid, Medicare, or DHAC care, free clinic care, or those residing in long-term care settings or receiving care from a licensed hospice, those in institutions including but not limited to incarceration and mental health, and persons including but not limited to homeless, HIV, children, women, economically disadvantaged, uninsured, underinsured, developmentally disabled, mentally fragile, mentally ill, migrants, military persons and their dependents, and veterans and their dependents. And there's an affirmative obligation for nurse practitioners to provide service into those underserved areas. I'll just conclude my remarks by saying that this is something that the stakeholder groups, the nurse practitioners, the physicians, I think really engaged in good faith, Mr. Chairman. And I think it's reflective. The final product that I'll offer up in the amendment that I was referring to is reflective of the increased degree of training that today's nurse practitioners have. It's reflective of the technology that we now have that allow physicians and nurses to communicate in real time through telecommunications and other electronic means. And I think it helps provide to the people of South Carolina additional access to healthcare services in a way that's good public policy. And with that, I'll yield to Julie to supplement my comments in that regard. But I think that this bill, in fact, updates our code and has it conform with what's actually happening out there today, both in terms of advanced nurse practitioner training, the way that physicians and nurse practitioners work with each other, and also takes into account the technologies that allow them to operate outside what has been a 45-mile radius.
Senator, it's also reflective of many, many hours of work that you've had on this issue for quite some time, and I appreciate your work on it and your report. Senator Scott.
For question.
Senator Yields.
And let me also say I really appreciate all the time and effort you put in this document. I noticed on page 5 of the amendment, you talked about those nurse practitioners on the doctoral level and master's and doctoral level. Most of them already going to be on the master's level, but on the doctoral level, did we give any additional flexibility with those nurse practitioners who do have PhDs in the field? Some of what the board may immediately be able to waiver in terms of what prescriptions they can actually be able to give to patients, since they've got that kind of advanced training.
Yes, I mean, really the essence of the bill talks about the practice agreement and a physician and the advanced nurse practitioner getting together and kind of specifying. But in addition to that, there are certain things that a nurse practitioner is allowed to do irrespective of the practice agreement, and that is to provide non-controlled prescription drugs at an entity that provides free medical care for indigent patients, certifying that a student is unable to attend school but may benefit from receiving instruction given in his home or hospital, refer a patient to physical therapy or treatment, pronounce death and sign death certificates, issue an order for a patient to receive appropriate services from a licensed hospice, and to issue a certificate that certifies that an individual is handicapped and whether that handicap is temporary or permanent for purposes of an individual's application for a placard. So yes, there is a modest expansion of those things that nurse practitioners may do, irrespective of what's in a practice agreement, but it is modest. And I will say, just very frankly, this doesn't go as far as I had initially hoped. I had initially hoped that we would follow the lead of some other states and truly allow these very highly trained medical professionals to render the skills that they're trained to provide. But I understand the reality of the political process, and I understand the reality of stakeholder groups, and I'm supportive of this amendment in that it does represent, I think, a step forward and does increase the access to health care, particularly in rural areas, Senator Scott. That was my main thrust here, was to try to get into those rural areas, and the 45-mile radius requirement, because of the location of physicians in urban areas, was really a hurdle that I wanted to get across.
Thank you, Senator.
Thank you. Any other questions of the chairman of the subcommittee, Senator Johnson?
Chairman, I want to see if the senator from Beaufort would yield for one question.
Sure, Senator Yields.
Just out of curiosity, were there any concerns or any opposition expressed in reference to this bill at the subcommittee?
Yeah, I mean, I think that and in fairness to the physician community, I think that they have long seen their role as being the ones that sort of provide direction and have the ultimate responsibility. And I think there was a reluctance or a discomfort in having nurse practitioners untethered completely from that particular role that they have historically played. And so as a result of that pushback, we moved toward this notion of practice agreement, where physicians and advanced nurse practitioners can collaboratively work with each other. And one of the things I should have mentioned, that in doing those practice agreements, it must be within the subject matter or an area within which that physician has expertise. So in other words, it can't be a physician entering into a practice agreement with a nurse practitioner in regard to an area in which that physician does not have expertise. Because ultimately, again, as we talk about in the practice agreement, it has to contain mechanisms that allow for the physician to ensure the quality of clinical care and patient safety. So given that being a material part of a practice agreement, it was important that a physician have expertise within that area.
Questions? Senator from Greenwood, Senator Nicholson.
Thank you, Mr. Chairman. I just want to make a statement. First of all, I just want to commend Senator Davis from Beaufort for leadership on this. I worked with him on this committee, and I can say, just like Senator Johnson said, that originally there was opposition, but I think they worked through a lot of this with the agreement, because I had a question in the beginning about, whether they had full authority or whether they were going to be in consultation with a licensed physician, regarding these individuals, because I think it's important that we have health care in rural areas. I don't want to make sure they have the best health care like everybody else, And I think we made tremendous progress with this bill, because they are going to be in consultation with the physician. If they're out there, they're going to have liability insurance, just like the physician and everything. So really, I think it's a movement forward, and they made tremendous progress in coming to consensus of how they can work together to provide health care for people in rural areas, because as we all know, that's one of the biggest obstacles that we have, is providing good health care in rural areas. Thank you, Mr. Chairman.
Yeah, Mr. Chairman, I will say that one of the perspectives that Senator Nicholson and Senator Bright Matthews, two other members of the subcommittee, brought to the process was focusing in on how do we get additional health care providers into rural areas, and I appreciate the assistance and perspective they brought in that regard.
Thank you. Senator Alexander.
Thank you, Mr. Chairman. And again, I just want to echo as well the work of the subcommittee chair and the work that's been done. And it's my understanding with the amendment that you have before you that you've brought all the parties together, and that's no small task. So I appreciate your work and your efforts, and it's certainly going to be improvement for the health care of the citizens, especially in rural areas like Oconee County. So I appreciate the work.
Mr. Chairman, I'm sorry.
While we are commending you, I want to add my voice to it as well. I am a bit concerned, and I know you expressed this earlier. First of all, I'm supportive of the bill. But it's such a rare occasion where we get together and can agree on expanding the scope of the authority of nurses. I want to make sure that we don't have to come back next year or the following year. I want to make sure that we expand it as much as tolerable by the interested parties. And so if there are further amendments that we can consider on the floor, and I understand that everybody was at the table, but given the lack of healthcare professionals available in not just rural communities, but urban communities, the nurses really I have found to know just as much, in some cases more, than the physicians. And now I say that I understand the physicians have a lot more training, but as a lawyer, you will you can know you're paralegal. Sometimes we have to seek direction from our paralegal, and I'm the one with the law degree. And so, look, in 2018, we want to give our nurses the ability to serve constituents when I get sick, and I got a great doctor. But sometimes it's hard to get in on the list, so I asked to see the nurse practitioner. And I've found that nurse practitioners give great care. And so to the extent, I understand this is a sensitive compromise, but I want to make sure that the midwives, the nurses, the nurse practitioners, and all of the nurses who have achieved the requisite educational criteria are able to practice without any unreasonable limitation. And I appreciate your leadership, particularly on the mile radius. As a result of telehealth, now I went to MUSC and saw that system at work and how nurses were communicating with schools. And I think that's a good thing. So I applaud your leadership, and I will be reviewing the bill to see whether or not we can expand in the areas that give more deference and benefit to the qualified nurses who are engaged in this practice. Thank you.
I'll just state, thank you, Senator from Charleston. It would be my intention, given the length of this bill and the ability of the members to read it and review it, it'd be my intention, if it is passed out and placed on the calendar, to place my name on it for at least a period of a week or two to give the members a chance, an opportunity to familiarize themselves, and to the extent that they think that amendments need to be drawn to it, that they have a chance to do that. So it wouldn't be my intention, it would be my intention to do that so that the members have a chance to review it more fully.
Chairman. Senator Johnson.
Yes, sir. I just want to say for the record that, earlier versions of this bill, I was opposed to because I thought that it expanded too much in the areas of nurses and nurse practitioners. And I felt that some of the things that were being requested, my position was that maybe nurse practitioners or nurses may want to go and become doctors. I think that there is a distinction between nurses and doctors, so I would be looking very carefully at any amendments that came forth to expand it further. But I do understand that some doctors were concerned, but I do want to commend the subcommittee chairman and the members for what they have here, and I can support this. But I think if we get to expanding too much, I think that may cause some trouble for the bill moving forward. And I think that's why I asked the question earlier about any concerns that were expressed at the subcommittee level. I want to be fair to the nurses and the nurse practitioners, but at the same time, there's a reason why people go a step further and become doctors, I think.
Thank you. Senator Hutto?
Thank you, Mr. Chairman. I, too, want to commend Senator from Beaufort. He's worked hard on this. And I just want to add one little friendly wrinkle into this that I think we need to. When you talk about the practice agreement, it says that it's the agreement between the nurse and the physician or medical staff. But
Right.
later on, it only refers to physician. And you can have a situation where you may have 4 doctors and 8 nurse practitioners, but if the doctor who signs it might not be the one who's on call that night. It needs to say medical staff throughout because the doctors would rotate who is going to be the person supervising the nurse practitioner, because if one doctor's on vacation, but they're the one that signed the agreement. So somewhere we need to go back and conform. The agreement clearly says doctor or the medical staff if it's 6 doctors in the office.
Right.
And we need to go back and make that consistent throughout.
Thank you.
That friendly wrinkle?
Mr. Chairman, I think Julie has copies of the compromise amendment.
They've handed it out.
They've been handed, okay. And at the appropriate time, unless there's any further questions, I would move that adoption of that amendment as a strike and insert, superseding the amendment that was passed in subcommittee. In other words, the document that I've been referring to is the compromise, and I would move to have that adopted and struck and insert into the bill.
Heard the motion. Is there a second? Second. Any other discussion? Hearing none. All in favor, raise your right hand. Unanimous? Okay. Thank you. Now, Senator Davis.
Move adoption of the bill as amended.
As amended. Got it. All in favor, raise your right hand. Got it. Thank you. Thank you. Next, tab F is 506, emergency refills. I'm sorry.
All right, what this bill will do is allow a pharmacist to dispense a one-time emergency refill of up to a 30-day supply of a prescribed medication. When the governor issues a state of emergency, the prescription cannot be a controlled substance and must be essential to the maintenance of life. Currently, right now, this is available, but only up to a 15-day supply. And as you know, in the past with some of the flooding and stuff, it was brought that maybe to expand that to a 30-day.
Mr. Davis, anything to add?
No, Mr. Chairman. I think this was reflective of, some of the dislocations we've had because of flooding and hurricanes and people having to leave the area. And it was thought that, allowing one-time emergency refills of up to 30 days would be appropriate. Again, it's triggered upon and only applicable when the governor issues a state of emergency. And so I think it balances convenience to patients against safety as well.
Straightforward. Any other discussion on it? Motion is favorable report. Second. All in favor, raise your right hand. Got it. Thank you. Next, tab G is 891, safe sleep practices.
What this bill does, it requires every parent, including adopted parent or parents that are adopting, to watch a video on the safe sleep practices for infants and young children. It also includes that this video must be provided to child care facilities or child care providers and healthcare providers to educate parents and the primary caregivers. If you remember back in 2007, the legislator had passed a shaken baby syndrome video, and currently right now DHEC is working to add that to this video. So it would be a one video for both issues.
Does it have a subcommittee amendment?
Oh, yes, sir. The subcommittee had decided to give DHEC just a few months after the bill goes into effect to make sure they have everything together. So it gave, instead of effective of the governor's signature, it gave it 6 months after the governor's signature.
Senator Davis.
Yes,
Chairman of
Mr.
Sub-
Chairman, we received testimony from members of DHEC who were there who indicated that a 6-month period of time would be ample to modify or adjust their videos to include this additional language. And so I would move adoption of the subcommittee amendment at the appropriate time.
Motion is seconded. Any other discussion? Hearing none. Motion is favorable report as amended. Any other discussion? Take it to a vote. All in favor, raise your right hand. Thank you. Got it. Tab H 4827.
This is a joint resolution, just to extend the date for a report that was due this past January. The committee is still meeting and getting everything together, so it extends it another year. So it's for a seizure safety and school study committee, and it would change it from 2018 to January of 2019.
Discussion? Motion is favorable. Seconded. Any other discussion? Hearing none, all in favor, raise your right hand. Got it. Thank you. Tab I, H 3926, compounding pharmacy.
H 3926 is a bill by Representative Spires. It's been around for 5 years. It's died on the Senate floor in 13 and 15. Last year, they did regulations to regulate compounding pharmacies. They did not have the statutory authority, so this committee told them to go and put it in bill form. This is in bill form. It's a non-controversial bill. It outlines how compounding pharmacies will be opened, and it keeps the FDA away from more stringent regulations on our compounding pharmacies.
Questions?
Somebody want to explain what compounding pharmacy is?
Compounding is, a lot of pills you get are just in a pill form. This is if you need a special prescription, like maybe for eye drops or some other kind.
Okay.
Any other discussion? Motion is favorable. Seconded. Any other discussion? Got it. All in favor, raise your right hand. Thank you. Passes. Next, we'll move to regulations. Tab J, Regulation 4740.
Regulation 4740 is promulgated by DHEC. It has 4 parts to it. Dietitians who are licensed by LLR will be allowed to prescribe diets if they're permitted in the facility's policies. This would be in a hospital or nursing home that a dietitian would be allowed to prescribe diets. The second part is in 2016, the General Assembly created the Safe Haven for Abandoned Babies legislation. Saying that a facility can accept physical custody of an infant who is not more than 60 days old. Prior to the passage of the Safe Haven bill, a facility could only accept an infant who was under 30 days old. So the regulation has to conform with the statutory change of the 60 days. The third part is inspections are required on all new additions and major alterations to facilities such as hospitals. The construction inspection fees are currently proposed by DHEC staff, adopted by the commission, and posted on their website. This is promulgating their fee schedules. There are no increases in the fee, but it is putting them in regulation so that the General Assembly will look at the fee schedule and not give that authority to the DHEC board. And the fourth part, in 2016, the General Assembly enabled the Pain-Capable Unborn Child Protection Act. Currently, a DHEC licensed hospital may apply to DHEC requesting certification as a suitable facility for the performance of abortions. This regulation amends it to conform to the statutory authority that the hospital will comply with Chapter 41 of Title 12, which is the pain-capable.
Senator from Lawrence, Senator Burden, Chairman of the subcommittee, anything to add?
No, sir, Mr. Chairman. Senator from Oconee and I heard these sets 3 weeks ago or so. We heard nothing but favorable testimony. I believe the trend in the Senate has been for the General Assembly to have a point of weigh-in on fees. So we have the promulgation by reg as opposed to board setting. I think everything else there, well, 2 of the points were, as Ms. Casto said, conforming to existing statutes. So we're recommending joint resolution to approve.
Okay, motion is approved. Any other discussion? Hearing none, all in favor, raise your right hand. Thank you. Next, tab K, Regulation 4760.
Regulation 4760 is promulgated by DHEC. You will remember in 2011, the General Assembly enacted the Stroke System of Care Act. the regulations are proposed to implement this legislation. The subcommittee did find that there were several places in the reg that DHEC did not have the statutory authority to put, they had a severability clause and a couple of other things. They were asked to withdraw and resubmit the regs. The regs you have before you are the withdrawn and resubmitted regs to clarify that how a hospital applies to DHEC for recognition as a stroke care.
Burden.
Mr. Chairman, the senator from Richland, Senator Jackson, has had a particular interest in this through the years. We heard, well, I apologize to interested parties that were not allowed or not given time to testify at the hearing. I heard from them subsequently, very supportive, Heart Association, Red Cross. But this system, when affected, should this is extremely critical. We talk about when seconds and even minutes and seconds count. The upgrading of this stroke care system is going to pay dividends. We have recommended a joint resolution to approve.
Mr. Chairman.
Senator Alexander.
I also echo my support, having served on the subcommittee, and I appreciate the agency pulling those and getting them back with the proper changes, and would move for approval at the appropriate time.
Motion has approval. Any other discussion? Hearing none, all in favor raise your right hand. Thank you. Favorable.
The next regulation is Regulation 4746. It's promulgated by Department of Health and Human Services. HHS has gone through their regulations, and this is strictly an update. There are no substantive change. The regulations have not been updated since 2001, so for 17 years. Changes include a recipient of Medicaid is now called a beneficiary of Medicaid. The old regs had the Health and Human Finance Commission. We know that it's now called the Department of Health and Human Services. The commission is now called a department. The Federal Healthcare Financing Administration is now called Centers for Medicare and Medicaid Services, or CMS. And the Social Service Block Grant Program is now under the Department of Social Services, and they deleted any reference to the Social Service Block Grant Program in these regs because they are now in DSS's regs.
Burden.
I think this is some of the work that transpired between the agency and oversight. So the effective work of oversight under restructuring is coming to bear here on these regs. We recommend joint resolution to approve.
Motion approved. Any other discussion? Hearing none, all in favor raise your right hand. Got it. Thank you. And tab M, Nurse Licensure Compact.
Yes, if you remember, there was a bill passed last year updating the nurses licensure compact, and so all this reg does is clean up to make sure it conforms with the current statute.
Burden. Motion approved. Motion is approved. Discussion? No. Take it to vote. All in favor raise your right hand. Got it. Thank you. Tab N, Regulation 4801.
This regulation just reduces 2 fees for the reinstatement of a license issued by the board. There was a minor typo in the regulations, so we went ahead and asked the agency to withdraw and resubmit, and that's been done. So it is correct now. It shows where the fees have been reduced.
Burden.
Well, Senator from Richland says that's unusual, but you know, LLR, I believe, is several times over the last 4 or 5 years has brought a reconsideration and reduction of fees through regs. So, yeah, encouraging. Motion approved.
And Senator Scott, you okay? Any other discussion? Hearing none, in favor raise your right hand. Thank you. That completes our agenda. Now raise your right hand and wave goodbye.